Program Spotlight. Now we bring you a discussion on integration of modern technology for the implementation of new criminal laws. The participants are Ashish Kumar Pandey, Advocate, Supreme Court, and Anubha Rohtagi, Anchor. India's three new criminal laws, Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam, which came into effect on July 1st this year, have incorporated modern technology in a big way to modernize the criminal justice system of the country. To discuss how the interplay between law and technology can result in better crime detection and also ensure criminal justice reform, I'm now joined by Supreme Court Advocate Ashish Kumar Pandey. Mr. Pandey, welcome to the program.
Thank you for inviting me.
An important aspect, or rather I would say the most significant aspect of the three new criminal laws is the use of technology at all stages of the criminal justice system, from crime scene visit to investigation to trial. So this integration of technology was a much needed reform, wouldn't you say?
There is a very popular perception that we don't get justice in courts. What happens whenever you go to the court on any day, you will get another date. And the entire process of justice delivery system is somehow vitiated. So when the parliament was deliberating upon what changes are required to be brought in for the purpose of overhauling of our new criminal justice system, so one of the concern was how to incorporate technology to ensuring that justice is delivered in a timely manner. Those gray areas where possibility of manipulation was there, that those gray areas can be removed, and especially considering the fact that we are technological superpower also as far as IT is concerned.
Yes.
So the objective of the parliament has been to frame these laws and incorporate those provisions in such a manner where these objectives can be achieved. So we will discuss it later that these objectives, there have been many provisions in these apps where these objectives have been tried to bring on record.
Now, yesterday, Union Home Minister Amit Shah, he launched 4 new apps, E-Sakshya, Nyaya Setu, Nyaya Shruti, and E-Summons.
Right.
And there is an expectation that these apps will expedite the justice system. So can you tell us more about each of these apps and their function? Let's start with E-Sakshya.
As we discussed, that various provisions have been added for incorporation of technology. So the first step which we are talking about is E-Sakshya. So E-Sakshya deals with how you collect evidence. So it has been mandatory for the investigating agencies, investigating officers, that when you go visit the crime scene, you have to record certain aspects of the crime, certain processes, and upload it on this app. So once the data is uploaded on the app, it has been sent automatically to a central server. And that data on the servers is available to every stakeholder in the criminal justice system, like investigating agencies, prosecution lawyers, defense lawyers, courts. So the process of further manipulation with that data is no longer there, while the original data is intact in the central server.
What about the next app, that is Nyaya Setu?
Nyaya Setu is an effort to bring every stakeholder on a single platform where different stakeholders like investigating agencies, prison officers, court officers, prosecution lawyer, defense lawyer, and expert witnesses are on the same platform. And this is very important step. You see, a lot of time has been in court process being wasted from communicating from one department to another department. So if there is a centralized system, a centralized platform where every stakeholder is integrated with that platform, that removes the possibility of wasting time only for the purpose of communicating with each other.
Let's move on to Nyaya Shruti, which is the third app that has been launched.
Nyaya Shruti is an effort to develop a system, an app, which will enable our courts to have our own audio-visual system where courtroom proceedings can take place. And whenever there is a date, because now these new laws permits us to have trial through audio-visual
Yes.
notes, so that app is an effort to develop a technological ecosystem where this process can be concluded through that app.
And the last app that was launched yesterday is the E-Summons app.
E-summons, somehow you see the process of court works in a manner where summons have a very crucial role, because whenever court requires presence of any particular person, that person may be a witness, investigating officer, or any third person, it works through summons. The first thing is they send summons, the person is available on the next date. And if that somehow the person is not there on the next date for any reason and rest of the stakeholders are there, the date is wasted, which contributes towards delay in criminal
Yes.
justice system. So this particular app ensures that everyone gets summons as soon as it is issued by the court, and that delivery is through e-mode. When there is an effort on physical delivery of summons, there is a possibility that that person may avoid accepting the summon. That person may not be present on the registered place, but when the summon is sent to his mobile on WhatsApp or through email, you cannot say that I have not received it because I was traveling somewhere, I was not present, because your mobile is always with you. This is the presumption.
Now, the new laws also lay emphasis on the use of forensics in investigations. How important are setting up of institutions for training in this field and establishing and increasing forensic labs for this?
Under new laws, it has been made mandatory that whenever there is prescription, that particular offense is to be punished by at least 7 years or more for the purpose of imprisonment. Forensic investigation is mandatory. And you see, this provision only has enhanced the scope of forensic investigation in such a large way that we need huge infrastructure for this purpose. Not only trained man force, but also institutions which will be required for training of those, that man force. So the emphasis has been to create new institutions. If I'm not wrong, 8 universities new being set up, approximately 45,000 new experts will be required for that purpose. So once the forensic investigation has been made mandatory, so it is going to serve us in a long way, where the process of manipulation can be removed from the entire criminal justice system. Because once the forensic investigation has been done, and now the other app we were discussing, that recording of the forensic investigation is required, and that recording will be uploaded automatically on the central server. So once that thing is done, even from a certain perspective, that removes the doubt from the mind of accused as well as the victim side. So the investigation is taking place in a fair manner, and the court will decide in accordance with the evidence.
Now, with the advancement in technology, there has been a rise in cyber crimes as well. So how can the increased use of technology be beneficial to tackle cyber crimes? And would you say that bringing in technology, incorporating technology in the new criminal laws was also important because of the rise in cyber crimes?
Yeah, one of the reasons why these criminal laws have been passed by the parliament is over the years, nature and scope of crime have changed. Not only the nature and mode of crimes, but the modalities which the criminals adopt to commit those crimes have also changed. So it was very much required that we have some sort of legal provisions in our general laws, because earlier what used to be the situation that we had IT Act which dealt with all these laws, and as far as our general laws are concerned, IPC was concerned, it was completely silent on these aspects. So now we have a system that there is no contradiction between our general law and our special law. So integrated system has been created where cyber crimes can be dealt. And very importantly, you see, under New Evidence Act, electronic evidence has been accepted as primary evidence. So it's very normal to say now the electronic evidence is the primary evidence. What are the ramifications? Even earlier that used to be an evidence. But from a legal point of view, you see, every evidence has to be proved in the court. When any evidence has been accepted as primary evidence, the burden on prosecution to prove that evidence in the court is on a lesser footing. It is much more convenient for the prosecution to prove that whatever they are presenting as evidence is actually true. And now consider this fact also, because forensic evidence and rest of the investigating process has taken place in such a way where there is a recording which was uploaded at the time of investigation on a central server. So when you integrate this entire system, you will find the entire criminal justice process have been made, loopholes have been somehow contained, and focus has been on to ensure that the process is speedier without there being any loophole where manipulation can take place.
Time and again, questions are raised about accountability and transparency in investigations. So what are the technology-related provisions that will enhance accountability of law enforcement agencies?
This is a very popular part of narrative, that now focus of these laws is not on dand, but it's nyay. These laws are people-centric. So how the process is being run on the ground? So one of the effort has been to ensure that there is a provision for online registration of FIR. Once online registration of FIR is there, any particular police officer, concerned police thana cannot say that they didn't receive the FIR, copy of the complaint was not lost. Similarly, there is a provision that a zero FIR has been made mandatory. The provision for zero FIR was even there earlier because of Supreme Court verdicts, but there was no mentioning of zero FIR in our official laws. So any person, if suppose you are traveling to any distant part of the country and something untoward incident happened to you, you can, in the concerned police station, you have an option to go to that police station. You can simply say that I want to complain about this particular thing, and they cannot say this is not within our jurisdiction.
Yes.
They have to register that FIR. They will send that FIR to the competent jurisdiction as per their understanding. Similar provisions are for EFIR. Now, other technology related provisions, you see, now as we discussed earlier, audio-visual recording of this investigation process has been made mandatory. Forensic investigation has to be recorded and sent to our digital servers. Various statements before the police have to be recorded. So whenever there is a recording, a digital recording, and then investigating agencies are no longer in charge of that particular piece of evidence because it has been sent to digital servers where they cannot tinker with those records.
Yes.
So obviously the scope of manipulation has been reduced. And when the scope of manipulation has been reduced, simultaneously a timeline has been prescribed
Yes.
that within these many days you have to complete any particular process. So now consider these facts: no scope for manipulation, strict timeline, and this automatically brings on record the accountability portion. Then the investigating agencies have to answer to their superior authorities or the court, why didn't you complete this investigation within this much period? And you cannot say that I have already completed or this was the problem, because you didn't follow the process, and the process had to be followed through these hours which have been lost. So this is an integrated system,
Right.
where objectives behind these new criminal laws have been tried to be achieved.
Now, these new laws mandate the digital recording of all stages of criminal investigation. We were talking about cyber crimes, the rise in cyber crimes earlier. With the rise in cyber crimes, security of this data also becomes a major concern. So are there any measures in the new laws to safeguard this data?
When the right to privacy has been made a constitutional right. So whenever data is being collected, and not only the government agencies, but even, you see, we live in a world where everything is interconnected and connected with somehow with the internet. So your data is being collected. Our life has become a product in itself. When other aspects of our life have been recorded on some server, somehow people find it very comfortable. But when the government tries to figure out what is happening with our life, although it is for the purpose of for the betterment of the people, somehow we find problem with this approach. Now we have to decide. It's a very crucial question. What we want? We want a speedier justice. We want a process where government can check that no manipulation is taking place. But for all these purposes, collection of data is very much required. Once the data is collected, and now you see the concern, prima facie you will find that people are worried that the government is collecting data, but that is not the concern. Reality is the people are more concerned that suppose there is someone who's officer who's in control of that data, and if he accesses that data without any authorization, the public can be somehow be in a position where they can be blackmailed. So how to avoid this possibility? In today's world, collection of data is a reality. We have to accept it, especially when that data is being collected for the purpose of betterment of public at large. Now the situation is how to put in place certain processes where misuse and excess of that data can be controlled. So obviously this has been concerned. Then when huge data will be collected, when recording, everything is being recorded, even statements are being recorded, and somehow if there is a hack and that data gets leaked, then any criminal element may misuse that data. So we will have to see that how these things will evolve over the years, but the process has been framed in such a way where there is control who can access to the data, that particular data, as required basis is the criteria. If you are not required to access that data, you are not given access to that data, and what the government is going to do with that data in long run, that has to be seen. We will very keenly watching this aspect.
Mr. Pandey, thank you so much for coming to our studios and for this very informative talk.
Thank you.
You were listening to a discussion on integration of modern technology for the implementation of new criminal laws. The participants were Ashish Kumar Pandey, Advocate, Supreme Court, and Anubha Rohtagi, Anchor. This program was produced and presented by the News Services Division of Akashvani. You can listen to it on our mobile app, News on AIR. This program is also available on our YouTube channel, News on AIR Official. You may share your feedback about this program through email at airnsttalks@gmail.com or WhatsApp on 9289094044.